I know I'm between you and a cup of tea or, a Thursday evening. Before I head into that, let's do a small exercise so that, you're quickly refreshed, right? And if I could probably request you to take your left hand in front and take one finger only and start tapping it. Okay, 2 fingers, 3, 4, 5. Thank you. Thank you for welcoming me. Fun apart, just wanted to break the ice and get going. Thank you so much. So wonderful to meet all of you. Each of them having different perspectives, each of them running different organizations. But one thing which I've noticed, just like how Anil and the chief guest was making a mention, how security has become more or less a common pillar, right? The next pillar which is now developing is the privacy. And unfortunately today, privacy today sometimes in India is a myth. To give a simple example, if somebody was to say, hey, there is a link where you can download something for free, or there is a link here where you can probably, get a 10% discount or some smartphone or something, you would find an increasing number of registrations going for it. And then there will be a small box over there, right? Sometimes not even visible to the naked eye. Sometimes it will automatically put a tick mark. I agree to the privacy policy terms and conditions. And if one reads that, you will realize that they can use your data for anything under the earth. Sometimes they can also go ahead and sell your data. And that's where regulation slowly started understanding. And I'm sure you would have faced this circumstance or situation. People call you for a credit card, they call you for an insurance, they call you for bank loan. They call you so much that you literally have to say, boss, I at one point in time I told them that I am a student, I don't have money. Then they stopped calling. At least that one service provider started calling 3-4 other people. Until my sort of information reached 3-4 people, I stopped getting calls at least for a period of 3 months. Then came an element of unsecured professional loan, overdraft loan. I don't know what all concepts are there. But when all of these are happening, you always get a little offended. Hey, why are people using my data? It could be those messages or promotional campaigns, whatever it may be. And with all this in the back of our mind, this is where the legislation came up with what is called as a codified data privacy law. You might be asking, did India not have a privacy law, or does it not have a law as on to date? The answer is it does have, but it is somewhere between the lines. For example, you have what is called as an information technology sensitive protection data rules. So it focuses more on the sensitive protection, sensitive data, and of course it goes and defines sensitive data like healthcare data, banking data, and others it does not speak about, and there's always a challenge. And that's where for the first time, this regulation, when it came up, right, everybody thought it was just like any other regulation, it will go through. So in fact, if I take you through the background of this, right, until 2017, India did not recognize privacy as a fundamental right. Which means, what is private to you, I am not recognizing that as a fundamental right of your own. Right? And it was believed that it was okay to encroach. In fact, we had a lot of legislations with regarding to trespassing and all of those. But in terms of usage of these sort of things, for the first time it got recognized. And that was a very famous Puttaswamy judgment, which eventually from 2018 to 22, a lot of variations came up. And finally in 2023 came a privacy law. Unlike the global standards, India came up with a privacy law only for digital data. Very interesting. So which means if you write personal information in a piece of paper, this law is not applicable. You take a photo of that, this law is applicable because it's a digital form. And obviously the possibility of a misuse in a digital form is way higher than that of a normal form. And that is the core intention why they went through it. So you can probably talk of, while I speak of these, you can think of multiple scenarios. For example, every time somebody comes to my office, a security guard maintains a visitor register. In that, what all details do I have? I have name, which company I come from, mobile number. Don't you think this three is a good information for, assuming it goes to a malicious person, it goes to a salesperson, it goes to a competitor. Let's say you have a sales office in a real estate company, you have a sales office. He writes that. So there's a guy who actually comes that day evening, takes a photo, sends it to a competitor, and that fellow calls you. Because that's how the market unfortunately works. Now, that sort of a thing which is in that paper form is perhaps as of now outside the scope, but the moment it comes into digital form, and that's when for the first time you came across what is called as the digital personal data, right? And the whole purpose of this law coming into picture was to protect the individuals. But the way we have to understand this is, tomorrow we as an organization, as a matter of today itself, we are handling a lot of personal data. And what is personal data? It could be name, email IDs. Of course, I'll give you some examples, right? And when we handle that, the whole question is, how do I safeguard and protect it? That's all about it, right? And many of them unfortunately think privacy is all about security. We'll probably, I'll try to demystify that as well. Interesting thing is, this act is already got the president's official signature on it. But the date on which it is going to be notified is not yet been told. But the industry estimate is saying that it might happen in next 6 months, which could be probably May to June, right? And if not 6 months, at least in a span of 8 months, I'm sure this regulation will come into picture. And at that point in time, things might become a little tangy. So it's better that we start taking the prep ahead, right? And a very interesting, this law, it is expected to be notified different dates, different sections. Unlike saying everything is applicable from today, like you would have heard of certain legislation, right? Like for example, the GST or some things like that, you would have heard that, it is applicable from so and so date. This law might have different applicability dates for different provisions. So I thought first I'll spend a few minutes. Yes, sir.
Is this delay in notifications because of the next year elections? So
could be, could not be. So maybe they want to abuse all the personal information and then bring up the rules. Maybe. Right. But in general, the industry is not prepared. In fact, some of them in the industry are asking even as much as even a year's time. But the government is a little more specific that you want to bring it in a span of 6 months. First, from a security perspective, I think most of us have already heard, understood, right? I'll probably spend some time on privacy. Privacy is not just, keeping the data safe, encrypted, all of those. The fundamental thing of a privacy is using the data for the intended purpose. You write your name and number in a register because tomorrow if some untoward incident has happened, at least I can call you up and say, hey, something like this happened. At least I can identify who that person is. The intention is not to send a marketing email. I go and register, I go to a Domino's Pizza and give my mobile number, not for getting a promotional SMS, but for me to get a bill. And because they say that, no, I need to give your bill, only I need to give your phone number, only then I can give you a bill, right? As though my phone bill and the pizza are interlinked, right? And that is where privacy is very different. It talks about how we are collecting personal data, how we are using the personal data. And to that extent, it's very different from security. In fact, you can probably say data protection that could involve elements of both. Elements of a privacy, elements of security. And that's why the law is not called as a data privacy act. It's called digital data privacy. Of course, it talks about elements of protection and all of those, right? So that's where the scope slowly gets widened. And in this, I'll probably speak about one key word, right? Personal data. Of course, data is a very generally understood. The word personal data means data about any individual, right, who is identifiable with such data. A simple example could be, you could say, hey, I have one of the top 5 actors coming to my store every weekend. and you generally will be able to know who are these top 5 actors. I'm just giving an example, right? Unless it is very relative, right? Or another example you can say is, hey, the oldest person in Kerala is a regular consumer of my Ayurvedic product. When you give that sort of a confirmation, that means you have not identified that person. But can I not identify who that oldest person is? The answer is, so even this becomes personal data. Look at that way in which we are articulating, right? Because they say any data about an individual which can be identified as such. As long as I'm able to identify, my dear friends, I think you have to be a little cautious, right? Second, digital personal data is referring to only data in digital means, which I already explained you what it is. And this is just some of the examples of personal data. Unfortunately, the law never explains what is personal data. It only uses the word which I just mentioned in the previous slide. What was that? Anything attributable to an individual person. Now, these are all few examples. We all know name is an example, mobile phone, email ID, bank account number. Today, even your Google Pay ID or a Phone Pay ID is a personal data. Because based on that, I can make transactions. If I have that, I can send you a pay request and you may probably accidentally hit accept also. And that's happening. That's happening as a fraud, right? I have this very interesting, yesterday I was reading through this. One of the so-called cybersecurity expert of US, right? Her family had gone for a vacation, and this was something which I saw on LinkedIn very recently. And for some reason, her flight got cancelled. Right? When you're in a vacation, you obviously want to be in a very relaxed mode, and your flight got cancelled. You're with family with a lot of hopes just to break out of your office or whatever personal life. And obviously you're frustrated, and what do? You start reaching out to all the airlines, customer care, and one of the popular thing we do today is tweet about that incident. Now what scamsters are doing is, they see the tweet of the person, try to catch hold of that, and calling you, saying that we'll issue a refund, here is a link. And that link is a remote monitoring software on your phone. Look at this. Look at the way in which, right? So, look at the way in which by you sharing your personal information online, how it could probably have an implication. And she herself is a cybersecurity leader who has been doing all these conversations. And so, this is where she said the latest trend is, when people are in mental agony and frustration and irritation, they are one of the victims for cybersecurity attacks. Look at this, right? And it's all misuse of personal data again, right? So which means anything which you look into it, right? These are all personal information. One of the classical examples is cookie ID, right? In India, there is no law for cookies. I mean, the privacy itself has just come up, right? In Europe, there is a law exclusively for managing cookies itself. Because using that cookie, I can sell what product it is. For example, today I've just browsed on Amazon or Flipkart one shoe or one apparel or one mobile phone. Next 3 days, it follows in all the websites which I visit. Right? Sometimes you would have identified one product which is, you have not verified, it is following you because maybe your family members have seen that browsing. It is able to identify certain things. All of these are cookie IDs, location data, handwriting, right? It again depends on scenario to scenario what information you are capturing, right? And when I come into this particular context, 3 very important definitions, and based on these 3 definitions, the entire law works. The first definition is the principle. In Europe or in US, they call this as data subject. Here in India, we call it as the data principle. It is nothing but whosoever personal data you are processing, that person is a data principle. As an organization, we are processing employee salary data. Employees are principal in this example. We are processing customers' data. Customer is a principal. We are processing vendors' data. Vendor becomes a principal. Okay, of course, they have given some exception in case of a child, because the child cannot give consent, in case of, aged people or those are medically unfit, etc., there could be some legal guardian. Next comes fiduciary. Fiduciary in the Indian context is nothing but data controller in the global context. And there is a very important word, means and purpose. He is the person who decides the purpose for which data is being collected and the means through which you are processing the data. Get this very, very clear. And many a times we fall under this bucket. For example, we as an organization, let's say we are running a hospital, we are collecting some data. We are running a manufacturing company, we are collecting some data. We are doing a service utilization, we are collecting some personal data about a customer. And the reason why we collect is because we have a defined logic. We want to send them a message, we want to remind them of their AMC, right? We want to remind them, or we want to send them their health report, whatever. So all of those, basically we are falling in the role of a data fiduciary. But the same we give some of this work to a service provider, let's say Soffit, or we give some of this work merely for the purpose of storage to a service provider such as a cloud-based application, a Google app, or let's say Google form, Microsoft share forms, right? You have a form which you can fill in. They become a data controller, because a data processor, because they are merely processing the data based on somebody's instruction. And who's that somebody? You and I, because we are collecting the data. So you take any scenario, predominantly if you are dealing with B2C, of course B2B as well, B2C, predominantly your exposure is way higher. So many of them say data privacy is applicable only to B2B players and not to B2B players. I totally disagree. Maybe the obligations are a little lesser, but the data privacy principle remains the same. It is saying that, just because I am sitting on the next to the driver's seat, I need not wear the seat belt, because it is not applicable for me. The law says it's mandatory only for the driver, right? But in case of an accident, we know what has happened, right? Including the, I think one of these Palonji Group's chairman or whoever it is, right? So processor, fiduciary, principle. These three are the critical touch points. And this is where the law entire thing surrounds. So you pick up any scenario, you will be able to identify one of them. If you are collecting and you decide the reason and the purpose, you will always be called as the fiduciary, right? Within fiduciary, you have one more category called as a significant data fiduciary. And these are not defined by the law, because we currently don't even know how these are going to be, but they've just given indicators. Based on central government may decide, based on volume. Example, a bank, the amount of personal data. In fact, bank runs only on personal data. Can you imagine a bank running without a personal data? The answer is no, because every transaction is relatable to a person. So therefore, the volume, sensitivity, the rights, risk to electoral democracy, like an Aadhaar database or a voter database, all of them, if they're having it, they could become a significant data fiduciary. Now here the challenge is, they could go ahead and say a hospital having more than 1,000 patients could be treated as an SDF. Now this is a little tricky thing. An educational institution having more than 1,000 students, I'm just giving 1,000 as an example, it depends on how the law notifies, could be termed as a SDF, right? A company which is having more than 500 customers and dealing only through a digital platform, a Swiggy hotel who is interlinked, who has a tie-up with a Swiggy or anything, they could also become. You may be an aggregator and you might become. So the way in which this will define is completely open-ended. And then comes a very interesting question: when do I decide this law is applicable, right? And for that, the first foremost thing which we look into is on the extreme left, right? I've just put in a small arrow mark to get started. It all depends on, are you processing digital and personal data? If the answer to this is anywhere no, forget it, end the story. But most likely that you would be yes in that. And then you go to the next question, are you processing in, by the way, I'm not yet told what is the meaning of processing. You give me a few minutes, I'll take you through the definition of processing. You will literally have a, swirl in your mind, right? So what, are you processing in India? And the answer to that is yes, of course applicable, but you are not processing in India. That means you're processing outside of India, but it is in relation to a service rendered in India. By default, the law becomes applicable, which means you are using a service such as a Zoom, which is not based out of India, but for a service rendered in India, it will be applicable. So Zoom will have to adhere to the data privacy laws, right? I'm just giving Zoom as app because during the pandemic they were the biggest players. Anything you want, Zoom it, or we used to have that. And this is where the definition of processing is very interesting. And on purpose I've put it on a circle, which you can correlate it, right? The dizzy thing. If you read it very carefully, literally everything under the sun can come under processing, right? Starting from just collecting, recording. I am only organizing, meaning I'm just formatting it. I am just taking it on my email and forwarding it. Structuring, storage, alteration, transmission, alignment. Look at this. Destruction of personal data also is a processing of personal data. That means the whole purpose of you obtaining personal data is to destroy. Say for example, some digital records are there you wanted to destroy and you are a certified partner. For you, this will be applicable. And this is where the game really changes, right? Now the whole purpose is just to give you certain concepts and to think where within my own pillars this could probably apply, so that you get the magnitude of the issues we are speaking of. And the law says you can process personal data only in two scenarios. Scenario number one, where the principal has given consent to the fiduciary. I repeat, principal has to give consent to the fiduciary or certain legitimate uses. Principal granted permission to fiduciary, permission rather I use the word consent, or legitimate purpose. And if a principal has to give consent, this is where the problem is. Principal and consent is like a marriage. Of course, marriage means there's a lot of things, right? Typically clash in terms of what? A fiduciary has to give a notice, and this is what is popularly called as privacy notice. And what on the other side? The principal has to give his or her consent. And who is the principal? It's nothing but the persons whose data you are processing. In simple language, any person who wants to process personal data, and we know what is the meaning of processing now. First step, what has to happen? A notice. Second step, what has to happen? Consent. And unfortunately, this consent has to be tracked and recorded. Because tomorrow, if that fellow sends a complaint to the board, unfortunately, the organization has to just pay 250 crores. That's the monetary penalty, right? And the word breach is very important. If you are using the data for a purpose other than the intended purpose, it is treated as breach. To give a very simple example, I have sent an email to you accidentally, could be treated as breach. I have put all of them in CC instead of BCC, which we sometimes do, right? It could be treated as breach. So you're understanding the landscape, right? So therefore, a notice and a consent is possible. Then comes the interesting question, what should the notice have? Whatever you see here is the expectation, and this is just a generative indication. The detailed guidance is expected. So by reading the principle based law itself, we are now slowly having a dizzy moment. And now imagine we go to the details of the rules, right? So it should be free, specific, informed, unconditional, unambiguous. So it should be very, very clear, on dot, to the purpose. And of course, the notice should clearly say, why am I collecting? How am I using? And what are your rights? right? And this is where it becomes very tricky. Of course, it'll over a point in time, what will happen is typically you will come up with standard notice formats which you'll copy paste and reproduce. But certain intricacies, I think you will have to understand from a business use case. And in case, very interesting, in case the data principal says, hey, I am no longer interested in you processing the data, you could withdraw and probably sometimes even delete the data, subject to a regulatory requirement. Suppose say law says you have to retain for 5 years, then you may have to retain it, right? Then comes the last case, where can you use it without consent? And this is the example of it. You can use it if it is voluntarily provided. You can use it if it is, he is not explicitly said, hey, I am not cancelling it, I am okay with it. By straight instrumentalities, or for, let's say, concerning public interest, pandemic, anything relating to employment is okay. So employment, by default, it is presumed that you can collect the data. So no consent required, right? But the same employment data you are sending for a background verification agency, it is suggested to have a consent clause, because the law says for the purpose of employment and those relating to safeguarding the employer from loss. Now you can argue that background verification is a means for you to confirm, hey, that this employee is genuine, no fake or some issues not there. But that you can do it, you can also process it to a third party. So the thin line is there, and normally we are suggesting that, in case you are using a background verification in your employment, put in a clause, we will use your personal data and you hereby give a consent for ABC, XYZ, right? So I'll probably pause here to take a few questions, your thoughts, any scenarios, before we probably take, last few slides. Yes, sir.
Looking at this, I think it will be impossible to share any kind of information or access information. How the media will work in this scenario?
So they've given a couple of exemptions for media-based industries. Right. Certain specific industries, some relaxations are definitely being given. But at this point in time, unfortunately, if I go strictly based on this, processing personal data without consent is now going to become a crime, literally. So therefore, the best thing to do is have your privacy policy clearly be mentioned and ensure consent is documented. And after you have documented, you use it. But the question is, you can use it only for the intended purpose. If I use it anything beyond the intended purpose, I need to again obtain the consent. Which means if he is not opted for the tick mark saying allow to send product updates, I cannot even send him some new feature.
Yeah, but that's from sales and marketing. Suppose if it's publishing a story about an individual,
there you will have to take a separate consent. Assuming, in journalism industry, whenever you are publishing about some person, right? Question is, as a journalism industry, now assuming a situation you are doing some cover story or you are doing some investigative journalism, you are publishing it, right? You cannot say that, boss, you are publishing against my personal, because a journalism industry by law itself is being given an exemption, even within the law itself.
Even if we leave out the journalism, suppose we are doing a LinkedIn post about someone, I listen to your talk and I make a post.
The first point, where I voluntarily provide the data, I am voluntarily sharing information.
Yeah, but I'm not seeking a consent whether I can publish in a social media platform, right?
Unfortunately, you can do it, because if a person, which means if a person, certain things, that way if you go based on it, right? I pick up a photo of a person and then I post it. Unfortunately, there is no bar as far as this law, strictly speaking, because if it's a post on a social media. Now, can I post a photo of a celebrity who's walking on the road and take a photo and send it across this thing? This becomes an interesting question. How can you take a photo of mine without my permission, right? So those sort of questions, as we speak now from a law, we do not have an answer. And based on the guidelines which come up, probably we might get something
through our portal.
Okay.
So what we do is that after do the assessment, we have to share the data with the client, whoever may ask the employee data. Then accordingly we find the competency gaps and other things. So in this law, what is happening is that while we collect this data, it is not just their number and we are collecting the personal attributes also. So this becomes very much applicable where
in your industry, yes.
Each instance, we have to specifically say how this data will be processed and a consent has to be obtained and this has to be recorded.
Yes, so I'll put it this way. Two scenarios. Scenario number one, assuming, let's say an organization, let's say ABC, is hiring your services for a pool of their employees or their potential candidates. In that case, you are only a processor, you are not a controller, because they are giving you the candidates, right? It's another matter, you work on a dedicated framework. Now that company, because you are processing the data, now it is their responsibility as to how you are processing the data, because the consent is predominantly who's deciding the means and purpose, them. So they will ask you so many questions and say that, okay, this employee, you will share the data only to me, you will safeguard it, you will not use it for any other purpose. You know, that sort of a binding agreement will be between both of you, because tomorrow if you use it for anybody else outside, right, as far as the candidate is concerned, candidate is given the details only to ABC Limited. ABC Limited has given you, your organization, the data. So I am just coming to, there are two scenarios over here. One scenario is your contact is routed from ABC to you.
Yes.
Then there is some bit of a saving grace for you. Now scenario 2, candidates approach you. In that case, you have to clearly articulate that, like for example, you are like a monster.com or a naukri.com where you are uploading certain information which people who have legitimate access can do it. So in that case, you will update your privacy policy where it says, hey, by the very fact that you're uploading your CV, sharing your personal data, it means that I need to process the data, and the only way in which I can process the data, because I have to give you a job or I have to give you an assessment and somebody has to see the assessment. So it is a legitimate, more than legitimate, it is the reason why I'm collecting the data. So mention this is the reason, this is the type of data which might get generated, and this is how we might probably share the information.
Is the liability of the processor is being well defined?
Liability of the processor is always between the agreement between fiduciary and the processor.
Okay.
The liability of the fiduciary is always defined. To give an example, right? So in this case, assuming the candidate is directly reaching out to you, right? In that case, you become the fiduciary because you are the person who is processing the data. Now you have to ensure as a customer that they will take care of the following, right? Because in this context, even though he is your customer, he is actually your processor in this case. So if you look into a simple example, if you take a corporate subscription of naukri.com, you will find the terms and conditions. That's just one simple example for you to correlate it. It's an interesting game. What you just said, if you just swap your roles, because at one point of time you are a fiduciary, at one point of time you are a controller.
No, we have another big challenge here. It's not just about the small data. We process very sensitive data. For example, like you are the employee of company X and company X is employing me. Now the question, what level of anxiety you have? What kind
I agree with you. I agree with you.
Data is what we process.
I agree with you. So good thing about this law is they have not defined what is sensitivity at all. They have not given a degree of personal data, which unlike the current information technology rules, there they say sensitive personal data where they talk about health records, wellness, those could be treated as a sensitive personal data, and they expect some reasonable security practices for sensitive data. That's all is the expectation of the current law. So tomorrow the rules might notify within personal data sensitive, highly personal, banking, etc. Like for example, if you US, if you look into it, health information, EPHI, those sort of a new categorizations which currently as we speak is not there. If that comes, then your element of data classification comes into picture. So you have to classify your database table saying, okay, this has highly sensitive data, go ahead. So today, even a blood test report, a mobile number, and your preference of food, all of them are personal data, all of them on par with each other as we speak today. But generally as organizations, it is recommended when you feel something is very sensitive, go ahead and do it. In fact, the definition of sensitive within Europe is very different. In one region, criminal record is treated as a sensitive data. One more region, it may not be. I'm just giving it as an example.
And this record keeping of the consent, it can be in a digital format.
It can be digital format.
It can be just a log of he is approving.
Yes. It could be a simple, even a Google spreadsheet where it says this time he is accepted. That's also fine.
While we use website, it can be just log.
It can be a simple log. But you need to demonstrate that. Unfortunately, how long you need to demonstrate is not given.
There is another thing that consent manager is there. Right?
Yeah, consent manager is a possible solution.
When account aggregator, we are going to have consent managers.
So the tricky thing in this consent manager is he is a third party solution provider. He will manage all your consent. So you can say it's like your KYC application. Like your KYC application, right? So you can say that, hey, this is an approved vendor through whom I validated. So consent manager can keep a track of it. So consent manager itself becomes a fairly large significant data fiduciary, if you ask me, because he is managing consent of so many people and things, right? There could be obligations on him, and that obligations of him and the fiduciary has to be agreed upon. Interesting game. It's only going to evolve. And as of now, what we are able to visualize is some scenarios which are coming through. The more we think deeper, it's just going to open up a Pandora's box. Any other question? We can move on, right? We'll quickly move on. Okay. So I think I spoke of legitimate users. One very interesting point I want to bring it to your attention is that the definition of legitimate use in the GDPR is a little open-ended. Whereas in the Indian context is very close-ended, which means other than this 5 to 6 scenarios, why do I say 5 to 6? I've just combined a few of them, right? That's why. Other than the 5 to 6 scenarios, anything else will not fall under the legitimate, right? Whereas in the GDPR, if there is an actual business use case and you're able to demonstrate, it can come under this. So I am talking based on the pure reading of the act. Probably if I go maybe 1 month down the lane or 6 months down the lane when the regulations come up, right, we might probably revisit this particular point. A few special points I think I made a mention. Personal data breach, anything that compromises the CIA of personal data, anything you're doing with an unauthorized use case of personal data will be treated as a breach. If you are a significant data fiduciary, right, those specialized category of people, few additional things which you have to take care is appoint a DPO. In GDPR, every organization which processes personal data should have a DPO, right? Whereas here we have that sort of a benefit. Appoint a data auditor. It's an again interesting word, right? We have a financial auditor, we have a technology auditor. Now we're talking about a data auditor, right? Do a periodic data protection impact assessment. Basically, what are the type of data you're collecting, what is the risk and things like that, right? And that's basically a significant data fiduciary. I think we spoke about a breach. Very interesting. Cross-border transfer. In the GDPR, personal data cannot go outside Europe, European Union and EEA. In India, they said if the personal data has to be stored within India only, it becomes very tricky because we don't have that much number of servers. So they said we will do something reverse. We will keep it a little open-ended, whereby other than the prescribed countries, I will allow you to keep it anywhere else. Say for example, they identified Afghanistan as one of the regions or ABC country as one of the regions. There you are not permitted to store your personal data. Anywhere else you are permitted to store. Why this is important is because many of the times we subscribe to certain cloud services without knowing where the cloud services is hosted. This is a very important point which you'll have to consider, right? In case the regulator itself says data has to be stored only in India, then that rule will apply. Example, BFSI industry. Insurance, banking, stock market industry mandates that the data has to be within the borders of the country. You use a cloud service provider, I don't mind, but that cloud service provider has to have data hosted in India only. In that case, it has to be in India. Just want to bring your attention, most of you, if you have companies, right, private limited companies, etc., there was a new rule from last year. The backup of your financial systems has to be in India. In case you're not aware, this is a new rule. Company law has been amended where there's a law, the backup of your financial and key financial application has to be in India. The original data you keep it elsewhere. I'm okay with it. Which means I am running on a US SAP server or Oracle server based out of California or Australia, no problem. The backup has to be in India. And there is a mandate that you need to take a daily backup. This is a requirement of the law. So you need to take a daily backup, again only for financial relevant application. Typically your accounts, payroll, invoicing software, anything relating to that, right? Procurement software, PO and other things. You might say, I am doing something, an operational system, but the invoice is also linked to it. Then maybe yes, there's a thin line, we'll have to probably interpret it, right? So that means, unless the regulator or some other law specifically mentions, you are permitted to have personal data outside of the country. Some of the penalties probably, I'll not go into the details. It basically ranges from 50 to 250, right? Unlike a GDPR, which is percentage based. A couple of insights I think I told on employees, I think I've already shared that in case you are looking at, a fairly larger game, or you're talking about a larger employee data set, you need not take consent as such because it's considered as a legitimate use. But if you're sharing with a third party, external service provider, etc., it is better to take that. From an action point, if I have to say, right, what we need to do. Probably a few steps, but I think the first step would be to understand where is my personal data in my organization and how is it stored. Because many a times that inventory step itself is missing. I don't have an inventory because the starting point of any exercise is to know where you are, and then you can talk of an exercise, right? It could be a simple weight loss program which we may probably take up, or it could be as complicated as implementing a system. So first is the discovery function, data discovery, tools may be used, processes may be used, interactions, etc. First get an inventory of your personal data, where it is stored, recorded, and then you go through this process like perform an audit, governance, policies, ensuring you have taken consent, etc. One of the interesting point which I keep getting a question in most of the sessions, if I have already having personal data, what do I do? So the law has given a small benefit there. If you are already having personal data, you are permitted to process. But the moment the law gets notified, they will give a certain period, maybe 3 months or 6 months. Within 3 to 6 months, you have to send an intimation to all of those people that this is the terms under which we are processing. If you do not want, you can take back your consent. And if they do not exercise any right, you are permitted to retain that data. So this is a favorable legislation to that extent. Otherwise, imagine if I had all my customer data and I have to expect everybody to give an authentication or a confirmation and only then process. So that means tomorrow you will have two sets of personal information. One pre-DPDP where consent is obtained or implied because you adhere to that regulation. And what is the regulation? Have a notice, send an intimation. Unless they have cancelled it, you are permitted to continue. And then comes newer fellows who have authenticated and coming into the system, right? So I think those are few things which I think I wanted to share. Not sure, I think you have a slide after that. I think just wanted to probably talk, how in general we are adding in value for our clientele system is, either do a gap assessment, a discovery exercise, a PII exercise, understanding what PII is, where you host it, where you save it, right? Third-party vendors, gaps. Again, for information, PII itself is not a word defined under the DPDP, but that's an acceptable industry acronym, right? Implementation, documenting process flows, bringing in a privacy framework, setting up policies, bringing in that. And last is, of course, periodical audits and things like that, right? And tomorrow there could be situations where data auditors are required, and once those rules come up, I think we'll be happy to be of help there. Thank you so much. I think I have taken a little more than probably 40 or 45 minutes. Happy to take any Q&A if you have, or we could probably pass it on to the panel or anything. Yes, sir, please.
Is there any this data information data audit which we mentioned about?
Yes, sir.
Is it mandatory?
If you are a significant data fiduciary, mandatory. If you are a significant data fiduciary, 3 things are mandatory. DPO is mandatory, data auditor is mandatory, DPIA is mandatory, data privacy impact assessment. These three are mandatory. Out of which DPO, obviously it's a regular affair. These two will become an annual exercise. DPIA, so DPIA I would probably say is a management driven exercise. Data auditor is an independent exercise done by an external party.
So one more consultant added to this.
Yes. Yes. Sorry sir, you had some question.
I do mainly software for hospitals.
Okay, sir.
So after
Looking into this, I think you might be able to think of something on those lines.
So what kind of messages I should really pass it to?
First and foremost is the hospital, in case they are collecting patient data, is first and foremost to obtain consent. And your software itself can build a feature where the consent module is there. So because you are dealing with a B2, whatever, a hospital service, EHS, whatever you call it, right? Like hospital managed, HMS or whatever. So you can build in a consent management system within your solution. That becomes a good feature. Second, how do you track that consent? And the intimation that if a patient is giving that form, they need to take a consent, and that could be by a simple signature also into a physical form. The only challenge is that physical form has to be kept for probably a period of 5 years or 8 years or whatever that retention watch they specify, because tomorrow if they ask how are you processing, here you're given your consent. So in their application form, generally they say I hereby give some sort of a general declaration will be that there should be another consent, I hereby agree for you to process, and at least the gist of the privacy policy should be mentioned in that.
Yeah, consent forms are already taken care.
Correct.
The question like, okay.
But the consent form is for processing your information, but it will not be under the DPDP law. So probably how that consent is going to mature, what is the privacy terms and conditions, only once the notification comes we'll get to know. But the fact that I have a consent management system and a backing up, that I think you can get started right now also.
Yeah, but my clients are already having a huge data with probably, okay, as you said, existing data.
But question is, how are they using? Are they going to reach out to all those customers? It's unlikely, right? The whole purpose of they keeping the data is tomorrow the customer comes back, the patient comes back, I have your medical history.
That's one part of it. Second thing is, by law they have to maintain at least for 8 years.
Law again overrides. Because by law I have to maintain, the concept of a consent will not come. Because the law, the first line of this act itself says, notwithstanding anything contained in any other law, right? So they say if any sectoral specific law is giving a much stricter provision, please go based on that and need not go based on this. So we basically see the stricter of the following in layman's language, whichever is more stricter.
Thank you.
Yeah. Yes, sir.
In the hospital sector, we are giving facility for the doctors to use a mobile app.
Correct.
There, the personal details and medical records are there.
Correct.
If a doctor share that medical records to an unauthorized person.
So the simple feature you have to do is disable sharing option.
Yeah. Even,
And if you feel a sharing is a legitimate business necessity,
even the screenshots and can be.
so screenshots you can ban it today, sir, because most of the most of these phones, right, apps, if you're using sensitive data, by default you can disable that screenshot feature.
Even when we get a terms and conditions for a doctor, before giving this app, you can't use this data.
So you can have the best of the agreements written, but if there is a way in which people can do it, a mischief will always happen.
But by the law, that risk is shared to the doctor also, or only the
Primary with the hospital, because you are the fiduciary. Doctor in this context is only a processor. So which means education becomes the biggest thing which we need to do. Awareness, bringing contextual examples and bringing awareness, because you may in these discussion forums or management forums you might talk so much, but the last mile, that person in the billing counter, what he does at the end of the, like, you know what, I think the chief guest was mentioning, somebody could just send the data over WhatsApp, so it becomes very tricky there.
I just wanted to add to what.
Yes, sir. Yes, sir.
We have developed a mobile app. Yeah, good evening. Yeah, good evening. I'm Dominic from Jubilee Mission Hospital.
Okay.
I'm the head of IT department.
Okay.
We have a software developed by our vendor for us, and it's a mobile app. We give to the patients this mobile app from which they can download their records.
Correct.
Okay, so when they click a lab report or a blood test report, it gets downloaded onto their mobile.
Correct.
Now, what if that patient shares it to somebody else?
That is completely outside our control. Because what we are doing as a hospital, my responsibility is to restrict the access is given only to the intended patient. The patient downloads and he sends it as a broadcast message or he uploads even in social media, we cannot do anything.
Yeah, fine, I got it. But what about a doctor? Even doctors.
The same doctor, let's put it this way, like, asking his question. Now you have a feature for the doctor. The doctor should not have a feature of a share. Assuming a doctor has to share, the question is why is he sharing? He might require to share maybe to a radiologist. He might be required to share for a secondary opinion. Then your app should have a feature sent to this doctor. And that doctor also should see that only through the app, not through a WhatsApp.
Unfortunately, this app developer, they say that these kind of reports cannot be just opened up automatically. It has to be downloaded to the mobile and then opened up in a PDF reader.
This is where the architecture entire thing requires a change.
Yes.
Because the moment you say, because what happens, I get your point. Because in a mobile phone what happens, the moment you see a report, the report you click on open, it interacts now with a third party application. Now this is a very valid point which you brought up. The moment it interacts with a third party application, now that app originally is gone, now it's completely with this. So now you need to build in a feature where, or they have to build in a feature where that report is visible only within that application. It's going to become tricky. Or they need to probably have an open source PDF reader application, and that PDF reader application is synchronized with this app. So when you're downloading this app, that PDF reader also gets synchronized. It looks like an independent application, but between these, it's like an MDM solution, right? Which is basically, I have a particular link or a browser which will not go outside that isolated bucket. Something like that we'll have to build it. It's a purely architectural solution which we'll have to solve.
This is already present.
It is there. The solutions are available. Question is whether that solution can fit into my scenario considering cost, challenges and other things.